Thank you very much, Mr. Speaker. I rise to move that the Acquisition of Lands for Public Purposes Amendment Bill 2024, Bill number 16 of 2024, published on the 22nd of November 2024, be read now for a second time. Mr. Speaker, this bill has unfortunately excited a lot of public attention, where a huge deluge of misinformation and distortion have been peddled about it in the public domain. And as a result, I feel compelled to elaborate for the listening public how those distortions are inaccurate and to allay whatever fears may have been excited in the public domain by those distortions. Mr. Speaker, I want to also put on the public record that last week I received a letter from the Honorable Christopher Jones in his capacity as Chief Whip, requesting a meeting to discuss these very amendments. I responded Tuesday to that request, accepting the offer to meet. I indicated in that acceptance letter that the Honorable Gail Teixeira will attend the meeting with me. A time and a place was fixed for the meeting as indicated in the letter. The meeting took place at the scheduled time and place, that is to say, 3 o'clock yesterday afternoon in the boardroom of the Attorney General Chambers. And at that meeting, Mr. Roysdale Ford, Mr. Ganesh Mahipal, Mr. Sherrod Duncan, Ms. Annette Ferguson, and Mr. Vincent Henry were in attendance. It was at the conclusion of the meeting, it was agreed that certain amendments would be made to one clause of the bill, that is, clause 3 of the bill, which seeks to amend section 24. The meeting concluded in a very harmonious atmosphere and with the common understanding that the parties were ad idem on what those amendments should be. One amendment or amendments to one clause of the bill. It was also decided that I should send a draft of that amendment earliest to Mr. Ford so that it can be examined, I suppose, to ensure that it met the expectations as discussed. The meeting concluded just after 4 p.m. and at 5:30 p.m., 5:29 p.m. to be exact, I sent an email to Mr. Ford with the proposed amendments as discussed. I did not receive any response from Mr. Ford to my email, and I sent it to two separate email addresses, Roysdale Ford at gmail.com, and I think Roysdale Alton forward at some other address. I didn't receive any response. I assume, therefore, that there was no other objections, and I proceeded to submit to the Office of the Parliament early this morning the amendments as per our discussions. I outlay that, sir, for the record, because unfortunately, I am hearing that there are still some disagreements in relation to the amendments. The meeting was, as I said, intended to address all the concerns. There were no prohibition against issues being raised. I consider it to be a thorough discussion. It was also conducted in a very good atmosphere, very cohesive atmosphere. And thereafter, I concluded that we would have addressed all matters of contention. Unfortunately, and yes, in fact, Madam Gail Teixeira and Mr. Mahi Paul took the occasion of speaking about meeting more often to get that kind of harmony and unity in our thoughts and work. As I said, unfortunately, I am hearing something differently. But in the course of my presentation, sir, I will address what the bill originally said and what the amendments are as per our discussions. But as I said, there is a larger question of dealing with the distortions that have been peddled. So, Mr. Speaker, the impression has been conveyed in the public domain that the government is moving for the first time in this House a bill that would authorize the government to compulsorily acquire private property for public projects. That is the first notion that I wish to reject out of hand. The law of Guyana, since it was a colony in 1914, reflected a power in the state that allowed the colony at the time, under the hand of the Governor General and the Colonial Secretary, to acquire public properties across the colony of British Guyana for public good. And that act, sir, is a 1914 colonial ordinance. When we became independence in 1966, it was incorporated in our law with the necessary modifications and adaptations, and it became the principal act, the Acquisition of Lands for Public Purposes Act, Chapter 62:05. It's quite an elaborate legislation, numbering 17 pages with 29 sections. The point I want the listening public to understand, first and foremost, that this law authorizing the state to compulsorily acquire private property has been with us for 1 century. It was there under the PNC government from 1966 to 1992, and it is with us now. So there is no new power that is being given to the government, the state, or the minister in question to acquire public property. In fact, I have heard also that this act and these amendments would run counter to the Constitution, because it is said, and rightfully so, that the Constitution protects private property. So I'll read from the Constitution, and I want the viewing public to see that this is the Constitution of the Cooperative Republic of Guyana. I have done it by hard copy for my own use and convenience. The relevant section of the Constitution reads, No property of any description shall be compulsorily taken possession of, and no interest in or right over property of any description shall be compulsorily acquired except by or under the authority of a written law, where provisions applying to that taking of possession or acquisition is made by a written law requiring the prompt payment of adequate compensation. So the Constitution itself, that guarantees the protection to private property, authorizes the state by a written law to acquire private property on once compensation is paid. Prompt compensation, adequate compensation is paid. Adequate compensation is promptly paid. That is what a law must do that authorizes the taking of that property. Now, this provision has been in our Constitution since 1966. The law that the Constitution refers to is the Acquisition of Lands for Public Purposes Act, Chapter 6205. So these are the two laws that have been with us from independence. So there is no new power whatsoever that's being given to the Public Works Minister to take lands for a public purpose that never existed before. That power always resided with the state. The next important point that I want to make, sir, is to explain the rationale for that law, as that law is not unique to Guyana in any form or fashion. That law is part of the legal arsenal of countries across the globe in recognition of the fact that the state is in charge of the public good, and occasion may arise where, to advance the public good, it may become necessary for the state to acquire private property for the public good. Obviously, with the underlying principle that when the state does this, the state must pay prompt compensation in accordance with the statute or the Constitution that protects private property. As I said, that is the legal position that obtains across the globe. And it is not, as I said, a new power, and it exists under the doctrine of eminent domain. And the principle of eminent domain is this: title for any territory within a state resides with the state itself. That's the fundamental principle. It is that principle that allows the state to come to you, the private citizen, to say, look, you own this property by transport, but there are minerals beneath the surface of the land that belongs to the state. And the state has residuary ownership over those minerals and mineral rights. That is one incident of eminent domain. The state, therefore, has that residuary power to resort to its original title to take that mineral from you as a private owner of property. Another incident of eminent domain is where the state needs the property for which you hold a title for the public good. Again, in exercising that eminent dominion, eminent means superior, dominion means control, possession. The state never loses that. You need that. And your title your title, my transport, your certificate of title are all owned by you, subject to that overarching power of an eminent domain which lies in the state to take that transport or title from you and pay you adequate compensation once it is for the public good. Obviously, you now have to have a law that sets out the process, the procedure that must be followed, and the principles upon which compensation is computed, so that the law doesn't run afoul with the constitutional protection accorded to private property owners. And that is why in every country there's a separate law that contains that procedure, contains that principle, and has provisions that will permit the computation to arrive at value. So, firstly, the minister can wake up one morning and determine that he will use this for the public good. The public good and the public project has a definition. So, when you decide to embark on a project and you want to take public property, it must satisfy the definition of what a public project is. It must be a project of the kind that will benefit the citizenry or a large section of the citizenry. Secondly, there is a procedure that is outlined on how the process must unfold. The people must be notified, surveyor must go, demarcate on a plan the precise area to be acquired, and then the question of compensation has to be addressed because you're dealing with people's private property. Now, let me put on the public record also that in 1975, there was an amendment done to our law, this very act, that pegged compensation not at market value, but at a 1939, 31st of March value. And the government of the day in 1979 to 1992 when it was changed, 1991 when it was changed, acquired a number of private properties, but instead of paying market value, they paid a 1939 value. So you were acquiring property in 1976, in 1977, 1988, all the way to 1990, but you are not paying market value, you are paying a 1939 value. And there are many cases that went to the court that demonstrated, and I can quote them if you wish. Comrade Ramjatan would know them. The Honorable Roysdale Ford, Honorable Comrade Ramjatan, and the Honorable Roysdale Ford would know them. That many of the properties were acquired allegedly for a national interest or for a public good, but never used for that purpose. And persons, after the change of government, after the wind of democracy would have permeated the land, went to court from 92 to up to 2000, up to now. And they have been getting back their properties because they were able to show to the court that compensation was not paid at all, because in many cases, compensation was not paid. Or that the compensation that was paid was not in accordance with market value. It was paid in accordance with a 1939 value. And worse yet, that the properties that were acquired were never used for the purpose for which they were acquired. Let me give you 2 or 3 examples quickly. The building that used to be Saijan Plaza, that was owned by the Singh family. They had a grocery there and a bar upstairs. Camp on Charlotte, that property was acquired for peppercorn consideration. Never used for the public purpose. They opened a departmental store selling Guyanese product in US dollars in order to raise foreign exchange. Saijan Plaza. That was not a national project. That was not the purpose for which it was acquired. The Singh family in 2009 instituted proceedings 30 years after, went all the way to the CCJ, and our government had to end up paying millions and millions of dollars in compensation for that property. That's one. The house of Jainarayan Singh Sr. on Lamaha Street, the house that used to be Jung Bahadur Singh House, was acquired. They said that they would put a national archive there, that it was a historic building. It was never used for the archival purpose. I, as attorney at law, represented the family and got an order restoring the property back to the family. There are dozens of poor people in West from Wealth, right by that school, Success Primary School there. That primary school. Not Success, the primary school in West from Wealth. A whole set of properties were acquired. No, they were acquired. I have the record to show, because it was believed that those persons, they used to work on the waterfront. And it was believed, part of it extended to Stevie housing scheme. And it was believed that they were members of the WPA. And the then administration took all those properties, but kept the people in it to hold it like swords of Damocles over their head. The state took those properties. A lawyer named Burjett Corbin filed an application. And when I was Attorney General, I took it to our cabinet. And I explained to the cabinet, this is what happened. Because they wanted back the property. And the PPP cabinet made a decision that I must go to court and consent for all those people to get back their property. And I can go on to talk about Tacuba Lodge. I can go on to talk about Hermanston, not Hermanston, the apartment place. At Chilabar Villas. I can speak about Hope Estate. All of those were private property acquired with peppercorn compensation. It was being used as a political weapon in this country. Once you raise your voice against the government, this was an act that used to be used, and you used to be paid a 1975, a 1939, 31st of March valuation. Weapon against people. So when we want to go down the historical road, we must understand the history of these matters. You see, the Honorable Member Amanza Desir is not here. She will come here to spew the misleading rhetoric, but she's not here to be educated and learn about the history. So, Mr. Speaker, I digressed into that historical foray so that I can put the public's perception into a historical perspective so that they understand. But let me be magnanimous and say that in 1990, it was the PNC government that moved an amendment to restore the position to market value from the 1975 amendment, where they pegged market value at 1939. I want to recognize that. And in 2001, we further amended the Constitution under the PPP government, where we added the word promptly to compensation and adequate to the compensation. Promptly to the payment. So when the Constitution, when payment is required to be paid, it is to be paid promptly. And compensation, whenever reference is made to it, it's adequate compensation. Now, when I listen to what is being said in the public domain by those who chose to platform the issue, it is clear as day that they did not read the Principal Act. So they read the amendments, which are only one page. Now tell me, how can you go and lecture publicly on a position where an amendment is being made to a principal law that is 18 pages, but you have not read the principal law? I am surprised because you still have, And I've been accused of being very naive. I have been accused of being very naive in life, and perhaps I am. I give my fellow human beings the benefit of the doubt, but I have been so roughed up with my naivety. Because when I listened, and there was a lawyer there, and I will tell you what the court, Mr. Honorable Member Royce Dilford was in court yesterday when we were dealing with these Harbour Bridge matters. You know what he told the judge? He wants the judge to take into account some person's property in close proximity. He wants me to disclose what is that person's compensation because his property is close by. And Cameron Ramjatan is asking why. The reason why it is irrelevant is because my suit is a different quality and price from your suit.
Vastly different.
And therefore, it will not value the same thing.
Don't compare them.
You pay for value. You pay for value. If the gentleman property is a mansion, then he will be paid based upon principles of value, the market value for that item.
Start with the money.
And here what he told the judge. He said you must take that is the thing. That is the distortion. He said exactly that to the judge. He said, Your Honor, this property owner was of Chinese ethnicity. And his client is of Afro-Guyanese ethnicity. And therefore he wants to know what the Chinese man got. The Chinese man got a business on the roadside producing food and all kinds of things. Multi-million-dollar property, different quality whatsoever. Different quality. But he asked the judge to take into account the ethnicity of the ownership, the race of the person. The judge said, hello, I have read all the law on this matter, and I can't see ethnicity and race being a factor. And the judge bid him goodbye. The judge bid him goodbye. He made that submission, and the judge basically told him to leave the court. So, Mr. Speaker, that is the kind of inflammatory, irresponsible rhetoric that is being spread. Now, you have Afro-Guyanese in that bridge project who got $80 and $90 million too, because their property value that. You have Indo-Guyanese who got $10 million too, because that was the value of their property. It had nothing to do with ethnic and color. You are a disgrace as an MP. So, look.
Oh, I am Honorable Attorney General. Please,
I am withdrawing disgrace comment. But Mr. Speaker, when you have to listen to these things, when you have to listen to the level to which they are descending in order to excite racial hostilities, it's a terrible, terrible thing. That's what I'm doing. I am simply putting on the public record what the debate is out there as a result of the misinformation that you have spread. So, Mr. Speaker, against that backdrop, I want to go to the law, the bill. So, Mr. Speaker, the bill says, Mr. Speaker, the First Amendment adds the word prompt to the word payment. So, Section 7 is being amended, and Section 7(1) that is being amended reads, and let me read it. At the expiration of 1 month from the date of the order mentioned in the last preceding section, and the date of the order is the date of the acquisition order, or any longer period fixed by the order, the land specified therein shall vest in the state. So once the order is published, the land is vested in the state. The state becomes the owner by operation of law. The state becomes owner, subject to the payment of the purchase money or on any compensation as hereinafter provided. You know what this amendment is doing? The First Amendment is subject to the payment. We are putting in the word subject to the prompt payment of compensation. You tell me by what measure of interpretation can this be bad for the property owner? We are saying that when the state takes the land, the current law says you're entitled to payment. We are adding the word prompt to the word payment. So you're entitled to now prompt payment. Oh my. And prompt, I had to explain yesterday, means immediate. Immediate. You're entitled to immediate payment. Anyone can check the Oxford English Dictionary for the meaning of the word prompt. The Second Amendment, sir, goes on to say the word adequate before the word compensation. Let's go to the law. So, land shall vest in the state subject to the prompt payment of the purchase price or of any adequate compensation as hereinafter provided. We are now putting the word adequate to compensation to further strengthen the law to protect the interest of the private property owner whose property is going to be acquired. And they are seeing the devil in this amendment. The government should be complimented for this because we are now bringing it in conformity with the Constitution. So let me recap that. The power to acquire is already there. What we are adding to it now is when you acquire and you are required to pay, you must pay promptly. And you must pay not mere compensation, but adequate compensation as determined by the Act. And there are about 3 sections that tell you how to compute the compensation. Honorable Member Figuera, are you now not clear? Have you not seen how they have misled you? So let's go to the Third Amendment. By inserting the words after the word provided, the words but without prejudice to the state's right to vacant possession of the land. Let's go back now. It's a pity I don't have a screen. So we're going to put the words in as I'm reading it. But I got to do it laboriously. So let's go back again. At the expiration of 1 month from the date of the order mentioned in the last preceding section, or of any longer period fixed by the order, the land specified therein shall vest in the state, subject to the payment of the purchase price, and we put in adequate and promptly, subject to the payment of the purchase price, right? Or any compensation as provided. Now the sentence doesn't, here in the law the sentence stops. All we are adding to it is these words, but without prejudice to the state's right to vacant possession of the land. The state already owns it. All and compensation must be paid. And all we are saying that the state must have vacant possession. Now, let us be realistic. If the state owns the land, by what logic should the state not be entitled to possession? Possession is an incident of ownership. The Honorable Member Ramjatan, you will not own and not be allowed to possess. Of course, your ownership underlies an obligation to pay. So that's all we are doing, Mr. Speaker, is giving the state a power when the title is vested to take possession. And why? Why? Because if the state is going through this extraordinary measure of acquiring property, compulsorily acquiring property for the public good, then why would you detain the state from taking possession when that's the whole purpose of the exercise? Because here you can possibly have one person who doesn't accept the state's offer of compensation to hold up an entire public project.
1 month to hold it up.
You need help, brother. I can't help you. You need therapy. You need therapy, my friend. So, Mr. Speaker, you have to develop a country, one, the interest of one, the whole concept of eminent domain. The whole concept of eminent domain is that the power of a few must bend and bow to the glory of the collective. That is what eminent domain means. That is what it means. I didn't invent it. That is why people like you will never ever see government again. Never ever see government again. Never see government again. Because you don't have the mentality that it requires to develop. You don't see. Mr. Speaker, let me pause here to say that when we did the Berbice Bridge, we had to acquire dozens of property at the Edward Village without any controversy whatsoever. When we did the Hope Canal, the lawyer was Moses Nagamotu acting for this government. Moses Nagamotu. When we did the Hope Canal, we had to acquire dozens of private property. We just completed the acquisition of 50 odd properties along the East Bank for the Berbice River Bridge. For the pipeline from Nouvelle Saunders at Crane from the seawall all the way to Viva La Force on the west bank of the Demerara River. Almost 10 miles beyond Wales Estate, we have acquired over 100 properties without a single controversy. One action we have in court, filed by Mr. Steve Surujbali. When we did the Crane to Schoonard Road, we had to acquire dozens of properties. And these are just months ago, and not a singular accusation of wrongdoing. Nobody has come forward to accuse the government of appropriating their property without paying valuable consideration. None, not a single one. I've given you right now hundreds of examples, live examples. 3 or 4 persons in the Demerara Harbour Bridge, all coincidentally represented, well, let me not go that road. But they had one valuation officer whose valuation they were relying on. And anybody in this parliament can guess who that valuation officer is. He produced a valuation that is 4 times the value of every other valuation officer that the government relied on, and the court. The court itself ordered valuation, and the court valuation came in line with what the government was offering. And that particular valuation officer was 400% higher than everybody else. 400% higher than anybody else. Always pissing about the place. So, Mr. Speaker, so that is what this bill does. And in our engagement yesterday, to their compliment, to their credit, the team with whom we met, and I mentioned their names, I managed to persuade them that Section 7 should be left without amendment. And I want to congratulate them for that position. Of course, they made proposals which we addressed elsewhere. So I want to put on the record, as of yesterday, the opposition team, and this was not a team, sir, that was speaking without the authority of the leader of the opposition, because the leader of the opposition also called me on the phone and spoke about the meeting. So they were there with the authority of the leader of the opposition. And when we finished Section 7.1 of the amendments, we were all at ad idem on Section 7.1. Concerns were raised and they were addressed in the other part of the bill. But the need for the state to get immediate possession, was accepted as part of the general law. And Mr. Speaker, let me show you what the position is in the rest of the Caribbean, because I got it here. In Trinidad, in Belize, you have the position where even before title is vested, you have the state having a power to go onto the land. That is the position in Trinidad. That is the position in Jamaica. That is the position in Belize. I can't find it. I'm trying to get it right here now, but let me see. If I don't get it in my reply, depending upon what is being said, I will deal with that. But Guyana stood out. Guyana stood out in that ambiguous provision that seemed to suggest that compensation must be paid. And that is what we are correcting here today. That compensation must be paid before possession is given. And that position, compensation is going to be paid. Obviously, it's going to be paid. You can't acquire property without payment of compensation. But the state's business must go ahead, and the parties always have a recourse for compensation. In none of the cases that have been filed, anyone has ever challenged the state's power to acquire over the last 3 years. Nobody, even in the Demerara Harbor Bridge matters. Nobody questioning the utility of the bridge. Nobody disputing that it's a public project. Nobody disputing that their interest should not subserve to the public good. All the issue was compensation was not what they expected. And it's only 5 or 6 persons. And they have a right in law to contest that. We are not saying don't contest that at all. And that is why in the act itself, you have about 4 sections that tell you what you must take into account in arriving at market value. Because that is what, in essence, the compensation is. It is what a willing buyer will pay, what a willing buyer will sell for, and what a willing purchaser will pay for the land at equal arm's length in a normal situation. That is how you calculate market value. So, Mr. Speaker, let me go to the amendments, the other part of the amendment. So, as I said,
Before you go to that, you'll need an extension, Honorable AG.
Thank you very much, Mr. Speaker. I'd like to ask that the honourable member be given additional time to conclude his presentation in accordance with the standing orders.
In accordance with the standing orders, you are allowed a further 15 minutes.
thank you very much, sir. That should be adequate. So, sir, in the current law, in the current law, if the state and the private property owner cannot agree on the compensation, the current law obviously allows for the matter to go to court for a resolution, and that's set out expressly. In the meanwhile, the current law allows the Minister of Public Works to issue to the property owner an advance payment, but not in cash, in the form of a bond up to 80% for that person to hold. That is the current law. We are changing that to remove a bond and to allow the minister to pay to the property owner 80% of what the government is offering as the purchase price or as adequate compensation, but in cash. How that can be wrong? We are removing a sterile bond, a bond that the people can't use, which they have got to hold on to until the matter is determined in the court. Here we are removing that and we are putting in the hand of the private owner 80% of what the state is offering for the land. How can that be bad? At what level can that be bad? Instead of a bond that they don't know what to do with it, we are giving them 80% cash. That, Mr. Speaker, was objected to at yesterday's meeting. And no, I'm going to get to what that formulation and what was suggested, which we accepted, Mr. Speaker. What was suggested is that the minister retains the power to pay the 80%, but it was suggested that the minister must not pay directly to the owner or to the person who presents himself as the authorized or interested person. The minister must lodge it with the registrar of the court, and the person entitled must then go to the court and show to the court that he or she is a duly qualified person to receive the money and get the payment. So they have added more expenditure to the person in their effort, I suppose, to defend the persons. They have added a layer of expenditure because now the minister can't hand over the money anymore. And the concern raised was valid. And let me be fair. The concern is, as I gather it, that the minister may not be able to determine who to pay in the event of a property dispute. Now, Mr. Speaker, that is a valid concern, but that will happen in the odd case. 90 or more % of the time, the authorized property owner will present himself. But in the spirit of compromise, and I don't have a problem, I want to shield the minister to ensure that the minister is acting properly. So the minister will make an application to a judge ex parte and lodge the money with the registrar of the Supreme Court. And those who feel that they are entitled to the money must go to the court, show that they are qualified to receive the money, and the court will pay them. And of course, the minister must do it as soon as the property is vested in the state. And that was there in an event, except that the person aggrieved had to write the minister for the payment. That was found objectionable. So we removed that and put an obligation on the minister. As soon as the order is vested, lodge the money with the court. We have no problem with parting possession with the money that we feel the people are entitled to anyhow. So whether we give them in their hand, or we put it in a bank, or we put it in the bosom of the registrar, that doesn't alter the principle. The principle is that we are paying what we consider to be market value, and we are giving access to the property owner with great immediacy, cash money that they can use, up to 80%. And that is the essence of what we agreed to yesterday. The other aspects of the amendment remained unaltered. But for neatness, we just removed 24A in its entirety, did the new additions, and the remainder is left as we are proposing in our original amendment. That is to say that if there is a mortgage on the land, the state acquires the land, we have to ensure that we protect the mortgagee's interest. So if the bank has a mortgage, we have to pay off the mortgage and then take possession. You can't defeat third parties' interest. That is provided for, and that will allow the property to be released in the hands of the state, free from encumbrance and or, well, the mortgage, which would be the registered encumbrance in this case. And also, sir, if the property is the subject of a trust or any type of settlement, then we have to pay the people who are the beneficiaries of that arrangement. That is expressly provided for here as well. But I suppose, like the other persons, they will have to go to the court as well, because the money is going to be deposited in the court. There is another last amendment which we have added, which did not feature in the discussion yesterday, but have addressed an issue that I believe the Honorable Mahipal raised. And Mr. Mahipal did some research, and I have to credit him with that. And he wanted us to establish some tribunal within the law to assess compensation. Mr. Ford and I were able to persuade him that to do that, you have to bring a whole host of new amendments, because that tribunal itself has to be like a court of law, because you're assessing the value of people's property. It means that those who constitute the tribunal will have to be particularly qualified to deal with proprietary interest. They have to have a regime of protection like judges before they can make such decisions. They must be independent, etc. To do that in an amendment of this type is beyond its scope. So, as a substitute, what I have done is to remove an archaic section from the principal law that says that the company clauses and powers consolidated ordinance 1846 shall apply. Remove that, because apparently this is a very old, doesn't exist anymore. But there was a tribunal established apparently where you can go and settle disputes. I am substituting the Arbitration Act of 2024, which we passed. So the parties, the state, and the property owner, invoking the provisions of that Arbitration Act, can appoint an arbitrator if they don't wish to go to the court and resolve their matter through arbitration, resolve the difference. The only difference that there will be, Mr. Speaker, will be the difference in quantum. And that's okay. No time you will find 100% agreements. Our experience has shown that we have had over 95% agreements in these cases. Because the state has not only used the state's government valuation officer, we hired private valuation officers. And the court and the people hired, the property owner had a right to hire their own valuation officers. And the court itself ordered a different valuation from a different valuation officer. So at any given time, you have about 4 valuation officers. And then the act itself, Section 18, Section 17, and Section 16, guide the court on how to calculate the compensation. For example, you are not to take into account any potential increase in value because of the impending project. You can't call a high price because a bridge is going there, so you can get an additional compensation. And these principles are there as they are in every other country. But in Guyana, I don't know why we have this proclivity to invoke and evoke a controversy when one doesn't exist and there is no basis for one to exist. Ramjatan seeing Leninism and Marxism in this bill. And this is a capitalist creation. It's a complete capitalist creation. But he's seen Marxism and Leninism. But that's what the people of Guyana, those are burdens that the people of Guyana will have to bear. Unfortunately. Fortunately, after next election, we don't have the likes of Ramjatan in the House. But so, Mr. Speaker, I will rest at this point in time, and I ask that the bill be read a second time. Thank you very much, Mr. Speaker.